Good evening. Happy Friday. I've got a few minutes before dinner, and so I figured I'd make a really quick video talking about discussing law and his 8 little common legal myths. Now, I don't know why he calls these common legal myths. These are things that he pulls out of his ass and attempts to answer and does so very poorly. The first one, he says that you can't recover attorney fees as a pro se party under FRCP Rule 11B. You can recover attorney's fees in the amount that you have spent on an attorney. Let's say, for example, if you had retained an attorney and then you had incurred attorney's fees fighting something, and then you had to fire your attorney because you could no longer afford to pay him, and then you continued on and eventually prevailed on that particular motion and you could then be awarded attorney's fees because you had spent attorney's fees, and you're a pro se litigant at that point. But attorney's fees are for paying attorney fees. That's why they call it attorney fees. You don't just get random money. You actually have to prove your attorney's fees. You have to show that you paid that amount of money and that it was a reasonable amount of money. So the attorney can't just throw in an extra, $20,000. You have to show it. It has to be reasonable. Even the amount of money you pay the attorney, generally speaking, has to be, in quotes, reasonable. So, generally speaking, no, you cannot recover attorney fees as a pro se party unless, for some reason, you spent money on attorney fees for that particular motion or whatever. The second, what he calls common legal myth, is that you must waive service of notice and attend a hearing if you're aware of it. No, but best practices is that you appear at a hearing if you're aware of it. Because if the other side has filed some sort of a certificate of service, or in California, a proof of service, the court's going to accept that. The court's going to say, oh, you said you served it. Well, let's move ahead. If they haven't shown up, it's on them. If you're aware of it, show up. Make your objections when you show up, but if you're aware of it, show up. His third one, this is from his October 20th. The third one is you can only amend your complaint one time, so you better not waste it. Well, I'm assuming he's talking about in a federal lawsuit, and you can only amend it once as a matter of right. You can only amend it once as a matter of right, i.e., you don't have to ask permission from the court. You just get to do it. And that is amending something or the other. Yeah. So amendments before trial. You can amend your pleading once as a matter of right. So, and you could do that once within 21 days of serving it, or notice it's not an and. So this dummy thinks that this is an and. You could do it once within 21 days of serving it and 21 days after service or responsive pleading. No. You could amend it once as a matter of right, either within 21 days of serving it or within 21 days after service of a responsive pleading. So you get one time as a matter of right. Now, the court will, generally speaking, allow you to amend it again as long as there's some reasonable good faith effort, yada, yada. If it looks like you could amend it to make it workable, then the court will do it. So you get once as a matter of right. And any more than that, it has to be either by getting agreement from the other party or getting the court to say that you can do it. And then he says it's illegal to ghostwrite for a pro se party in the First Circuit Federal Court. Yes, it is. It absolutely is. You can see this is Pease versus Burns. This is a District Court of Massachusetts 2010 decision. It does reference First Circuit decisions, and it also is within the First Circuit, but it's not a circuit court. It's a district court. But you can see that in Ellis versus Maine, they note that a lawyer substantially participating in the drafting of a pleading would violate Rule 11 by not signing the pleading. In this particular case, Piccone was an attorney. He was not licensed to practice in Massachusetts, and he ghost wrote some stuff, and then he signed it. And they said, well, you got to sign it. The practice of ghostwriting legal documents is inconsistent with the procedural, ethical, and substantive rules of this court, and a lawyer should disclose to the court his or her preparation of any litigation documents, even a single pleading, as well as the limited scope of the representation, because you're representing the client if you are ghostwriting documents, and you do need to sign them, or else you're violating Rule 11, at least according to the First Circuit Court of Appeals. And since Piccone was not authorized to practice law, it was an unauthorized practice of law for him to ghostwrite for a pro se party. So the answer to this is yes, it is illegal to ghostwrite for a pro se litigant in the First Circuit Federal Court. If you are not an attorney, you're engaged in the unlicensed practice of law. If you are an attorney and you're licensed to practice within that particular district, then you'd be violating Rule 11 if you don't sign it. Rule 11 says that every pleading must be signed by at least one attorney, and if you prepare it, you got to sign it. So that completes this one. I'm sure that he got every single one of those wrong because he's not that bright. Then this one, it's a common legal myth, apparently. Apparently this is a common legal myth that it's okay to harass mediators and your opponent's legal team. First of all, it's phrased stupid. Your opponent's legal team is your opponent's attorney. It's only sovereign citizens and these wackadoodle pro se litigants that think that they could have a, quote, legal team that's comprised of like paralegals and legal assistants and stuff like that. That's not a legal team. A legal team is your attorney or your attorneys. That's your legal team. And mediators, generally speaking, are licensed practicing attorneys or retired judges, and those are typically who you get to mediate. And when I'm talking about mediators, I'm assuming he's talking about, since it's a legal myth, a mediation that would take place between two parties. Now, one thing that apparently Discussing Law and Chile don't understand is that mediators must be neutral. If they're not neutral, then they're not mediators. You have to be neutral. You can't be biased. Mediators, arbitrators, and judges must be neutral. And so he's not Discussing Law pretends, I guess. He's apparently alleged that he's licensed to practice law in two jurisdictions. He's a member of 2 state bars, allegedly. He doesn't show it, and I don't believe he is. And he has also held himself out to be a professional mediator and demanded fees from somebody for it. I would posit to you that might be unlicensed practice of law. It would depend on the jurisdiction he's in and where the filing is and all sorts of other things. But that very well may be unlicensed practice of law. His second common legal myth for the 21st, and this is a common legal myth apparently, according to him, is that you can't have John Doe parties in a civil suit. Now, a party is a plaintiff or a defendant or a cross-complainant or a cross-defendant. That's what a party is, or a petitioner or a respondent, if that's the particular nomenclature for the matter that you're in. No one has ever suggested you can't have John Doe parties in a civil suit. It's common practice to name Doe parties, like Does 1 through 10, in a personal injury case or something like that, where you don't know necessarily all the parties, because maybe it wasn't just the driver of the car that was at fault. It might be someone who did an improper repair on the car. It might be the owner of the vehicle who might also be liable to you. It might be the person who lent the driver of the car who might be liable to you. So you will often include Does in the complaint to stand in for potential parties who are liable to you. Now, as soon as you find out who that John Doe party is, you have to amend your complaint. And it's a simpler procedure. You could just amend you file a supplement to your complaint that says, John Doe number 1 is actually Billy Bob McGillicuddy. And so everybody knows in the lawsuit who the party is. You don't have parties who are anonymous. They're just unknown at the time you're filing the complaint. As soon as they're known, you file a supplement to the complaint or an amendment to the complaint, and you name them in the lawsuit. If they're not named, they're not liable for anything. And I believe he brings this up because it's patently obvious that you can't have anonymous witnesses in a civil case. Now, if the civil case is something that's under seal, like if it's a probate case for adoption or something like that, and it's going to be sealed, then great. But the parties all know who the witnesses are. The parties know. The parties have access to all this stuff. Now, in Pacer, they can do filings that aren't available to the public. They're sealed filings. But the parties still have access to it. You can't have one party playing hide the ball with an anonymous witness and think the court's going to be cool with that. Both parties have to know who the witnesses are. So that was not a common legal myth. His third one is it's okay for non-parties to delete relevant communications in an action. It's the only burden on you is that you have to reasonably expect that you're going to be a party to a litigation and that the other party is going to need that particular data, that particular document or what have you. And then you have an obligation to preserve it. That's the whole spoliation thing. So non-parties can delete whatever the hell they want because they're not parties. And a party just has to make reasonable steps to preserve the data, to preserve the document. It doesn't mean that they have to somehow freeze their Discord or file a lawsuit against Wicker or Snapchat or whoever to prevent them from deleting things. And it's you don't have to do that. You don't have to do that. The data, whatever it is, has to be in your care, custody, and control. You have to have access to it, and you have to preserve it. I don't think that this Wicker thing is going anywhere. If it was texts that were just normal texts that didn't automatically delete, I think, and so that they stay on your phone, and you failed to preserve them, you delete those. Maybe there's something there. But this whole Wicker thing is it's a lark. It's stupid. I get what they're trying to do, but it's stupid. And finally, a Discord server owner is protected by Section 230 of the CDA. Absolutely, 100%, a Discord server owner is protected by Section 230 of the CDA. 100%. This is 47 USC Section 230, Section C1. No provider or user of an interactive computer service shall be treated as a publisher or speaker of any information provided by another information content provider. So no user. Kate is a user. She may be also a provider since it's her server. Discord is definitely a provider, but Kate is either a provider or a user. So anything that anybody else says under Section 230 is not attributed to her because it's another information content provider, i.e. another person who made that post, who published that statement. It being on her Discord server, she is protected under Section 230. So, sorry, civil liability. No provider or user of an interactive computer service shall be held liable on account of any action, blah, 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 any action taken to enable to make blah, 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 yada, yada. So, sorry, but Kate does have Section 230 protection because users are protected by Section 230 of the CDA. So, I'm sure he got every single one of those wrong as well. Anyway, that's discussing law. Thanks for watching. Have a great day.